case briefs, and so much more. LS Data's got what you're looking for.
The United States Court of Appeals for the District of Columbia Circuit heard the case Meat and Highway Drivers, Dockmen, Helpers, and Miscellaneous Truck Terminal Employees, Local Union Numberable 710 Volts, National Labor Relations Board in 1964. The case focused on whether labor contracts could contain secondary clauses intended to harm non-union interests, and whether strikes aimed at achieving these clauses could be considered unfair labor practices. The dispute began when truck drivers from various packing companies in Chicago, represented by the union, noticed a reduction in employment for local drivers due to changes in the distribution of meat products. The union's proposals for work allocation, union standards, and union signatory clauses were initially found to be void under the Labor Act. However, the court later found the work allocation clause to be valid, as well as the union's proposal for local drivers to make the last leg of out-of-state shipments, as long as both parties understood and agreed to the clause. The National Labor Relations Board determined that the union's strike to achieve clauses prohibited by the Act was an unfair labor practice. The court partially enforced the board's order, setting aside one order extension and enforcing another, but remanded some questions for further consideration. The court emphasized that specific clauses and actions required case-by-case evaluation to determine compliance with the National Labor Relations Act.
Case briefs, and so much more. LS Data's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.